People are telling me in the chat. Okay, so today we're going to be talking about the fundamentals of legal writing. We have never done this before at the CLC, so we're really, really excited. We do a lot of publishing of legal work, and we edit a lot of work here at the CLC. So we kind of thought that it would be good to have a workshop on what is good legal writing. Now we're only going to be doing this for 2 hours, so I understand that I can't teach you everything and I can't have you like do exercises or anything like that, which would be really, really helpful. But if by the end you can, you're focusing on using the active voice, you're like no legal jargon, short sentences, clear, efficient writing, and you just have that in your head, that is the ideal thing. I actually was not taught legal writing until I got to my LLM. Before that, I thought I was a really good legal writer, and I had a legal writing class, and the teacher basically went through every sentence of mine, and she was like, what are you trying to say here? What are you doing here? Why is that here? Why have you put this down here when you're referring to a point back up there? And when you have that kind of like, someone scrutinizing your work on every sentence level, it actually changes entirely the way you think about your own. Sorry, we had an issue with connectivity. Let me share the screen again. Okay, there we go. So as I was saying, yes, we're going to keep on going through all of this, and we're going to talk about it in a lot of detail. I kind of want this session to be very participatory. So if you guys do want to, give your comments in the chat, or again, raise your hand, I would quite like to hear from you guys about what is the essence of good legal writing for you? What are the things that you struggle with? What are your pitfalls? Okay. Most lawyers write poorly, but so what? This is the outline. This is what we're going to go through. We're going to talk about accuracy. We're going to talk about clarity. We're going to talk about conciseness, which doesn't really mean brevity. It doesn't mean producing work that's short. It just means producing work that is very, very efficient. We're going to talk about structure. We're going to talk about length, and we're going to talk about how you develop your own voice. Okay. Let us start. Most lawyers write very poorly. Modern legal writing is obscure, boring, redundant, disorganized, dense, unimaginative, impersonal, foggy, confused, heavy-handed, jargon and cliche-ridden, weaseling, pseudo-intellectual, hyperbolic, bloodless, pretentious, or convoluted, rambling, incoherent, archaic, and fuzzy. So, screen sharing isn't working. Okay, why? Sorry, we're just having some technical issues. Oh, there we go. Is it working now? Can everyone see my screen now? Yes, they can, but how can I see it? Sorry about this. Okay, there we go. Yeah, good. Okay, first time we're doing this, so please bear with us. Okay, it should work now. Modern legal writing is obscure, boring, redundant, disorganized, dense, unimaginative, impersonal, foggy, confused, heavy-handed, jargon, and cliche-ridden. Weaseling, I will talk to you about weaseling, what we mean by weaseling words, pseudo-intellectual, hyperbolic, bloodless, pretentious, convoluted, rambling, incoherent, archaic, and fuzzy. So what? Who cares? We care because it's a waste of time. It wastes the valuable time of the reader, judges, clients, other lawyers who must constantly reread documents to figure out what is meant. Also, I kind of want to mention that it really does waste your time also, because then you have to keep on rewriting the work, editing it, that kind of thing. Whenever I read briefs and they're very convoluted, you can tell that the person doesn't understand what is being written themselves. You need to then go back and be like, go back, do the research again, figure out what you're trying to say. So yeah, essentially it's a huge waste of time. It loses cases. Some of you will be lawyers. I think a lot of you are law students, some of you are lawyers. And when you're working at a law firm and you know the kind of cases that you get, this is especially for people who work on human rights stuff, constitutional law, petitions, appeals, notices, articles, and letters that do not adequately convey a writer's point, give others who are better writers the opportunity to portray their own positions more persuasively and sympathetically. We are lawyers, we deal in the business of words. We need to make sure those words are pretty. Also, it's literally your job. It can lead to disrespect for or indifference to the law. The public can't understand what lawyers are saying because the law itself is almost always obscure, and the lawyers' attempts to explain it are rarely clearer. We're going to go through this in a bit more detail later on. I mentioned this point, but it's almost like we want people to not understand what the law is because that gives us a special status. It's our profession. What do you mean you don't know what res judicata means, or like a writ petition means, or how it goes through like an intercourt appeal, that kind of thing. So we almost want the law to be in this ivory tower pedestal. We want to use legalese. We want to do all of that kind of thing because it gives us a false feeling of importance, I think, especially when you encounter a lot of people using Latin when they don't need to be using Latin. And the effect that has on the public is they're like, I need a lawyer to explain to me what the law is. And that shouldn't be the case. What the law should be is very clear. And unfortunately, it's not. But when a lawyer explains to you what the law is, it should be very, very clear then. And often it really, really isn't. Often lawyers do the opposite in that they really confuse people with what the law is. And in doing so, you have to bear in mind your audience. And I think for me, the greatest minds are those that can explain a concept really simply. And I think you need to think about it in the sense that, can I explain this to like your 5-year-old nephew or 8-year-old nephew? I remember when Stephen Hawking was asked by a 5-year-old, what happens when if I were to go into a black hole, what would happen? And I mean, taking into account the audience, he's with a 5-year-old, right? He's not going to be like, so this is what happens to your particles on like a micro level, blah, 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 you know, this kind of complex physics stuff. He didn't say any of that. He just said, you would turn into spaghetti. And I thought it was just such a clever way of articulating such a complicated subject. So simple is always better. Clear is always better. We should write well because you can be a good lawyer or judge and a bad writer, but you can't be a great one without being a good writer. Good style powerfully improves substance. Indeed, some people think it largely is substance. It's like, you know, when you talk about writers, when we're talking about Fitzgerald, Hemingway, we say they either have style or they have substance. Hemingway is all style. I mean, there's no substance there whatsoever, but it makes for a really engaging, really fascinating read, especially if you don't have much of a case. You really want to make sure that you're hitting all of those style points because you want to impress and you want to do your duty to your client and you want to make sure that they have the best shot possible. So to do your duty to the client, to law generally, to the court, all of these fancy terms, to justice, you want to have good writing. And as lawyers learn to write well, inevitably the public will learn to understand them also. So that's the entire point. Okay, lies we tell ourselves about writing. I do my best work under pressure. I've been known to use that one on many an occasion. Most of the time you don't do your best work under pressure. It's just the quickest time you can do the work because you have a deadline. And so you have to finish it in 3 hours. It doesn't mean that is your best work. I'll start on it tomorrow. It should only take me 2 to 3 days. On average, your work usually takes 3 times longer than you think it will take. And that is definitely true for me. And also there's Parkinson's law. So if you leave a week for an assignment, it will take you a week, even if it's not meant to. But start on it today. The best thing that I can tell everyone is when you're writing, start on the research, start on the writing. Once you're done with the research and you want a few days off before you write, just start writing and then start editing. Once I finish these brainless admin tasks, I'll work on my magnum opus. I have never had a cleaner room than when I want to start writing on an assignment, because I'm like, let me do all of this other stuff first. Let me water the plants. Let me send an email to that woman I didn't reply to 3 years ago. That's something I really need to do. And then I will do my work. But yeah, it's all about just getting started. To write well, develop a theory, write it down, research, take notes, jot down a rough outline, reassess your theory, explain it to yourself on paper, set down a formal outline, compose, reorganize, rewrite, edit, and edit again, and proofread. For those of you who work in law firms, the last two are really difficult to do. And I know from when I worked in litigation, it was such a time crunch that you literally had to get your work done that night. You had to write that repetition, you had to write that appeal, and you had to submit it. You don't really have that much time to edit and edit again and to proofread, but it is really, really, really important. The amount of spelling mistakes that you realize, or, you know, when you've used like there and they're like wrong, that and which wrong, is really, really important to give yourself some time to edit, some time to proofread. I know that that's not always possible. Those of us working in research, we have a lot more time in which we can actually do that. And for those of you that are students, try and give yourself that time. Try and compose early and then edit. I know these are like magic, you know, I'm thinking about rainbows and unicorns and all of that kind of stuff when I talk about this stuff, but it's really, really important. The editing process is one of the most important processes in writing. This is how roughly it should be broken down for you. Research should take up 30% of the time. Writing should take up 40% of the time, and editing should take up an entire 30% of the time. So my issue is that mostly I do the research and then I write after much agony. I'm there writing, and then the editing, I'm just like, give it a quick proofread, and I'm just like, oh my God, it's incredible, or it's terrible. What on earth have I written? And I don't spend enough time going through and doing, you know, asking myself all of the questions that I will teach you guys to ask yourself. So this is a good reminder for everyone, including me, about how we can learn to write better. This is kind of the writing process as it looks for me. I'm sure a lot of people would also agree that this is what it's like for them. It's not the prettiest thing to be writing. And my job is to write because I do research and I do international law. So imagine my life. Yes. Okay. These are the main things that we need to look at and that we're going to be talking about in more detail. I hope I'm not being too fast. Am I being too fast in skipping through everything? I will try and slow down. Accuracy, that is the main thing. We're going to be talking a lot about how we have to be incredibly accurate in what we're saying. We need to avoid dogmatic expressions, like it is very clear that it is incontestable that this is the case. I mean, it wouldn't be, because the law is never that clear. It's never that incontestable. So maintaining accuracy in your writing is incredibly important. At the same time, we have to be really, really clear. And we're going to be talking about how we can improve on clarity, especially in language, and about how we can make it very concise in how we're speaking, right? Avoid jargon, avoid like overly pretentious uses of phrase, all of that kind of thing. So let's get started. So we need to prefer the familiar word to the far-fetched. When you have a familiar word that everyone can understand, you kind of often feel like, no, I want the really, really fancy term that, you know, makes my writing look really flourishy and Shakespearean and lovely. It is so much better to just use the familiar word and to totally ignore the far-fetched one. And I know for me, it's just like I'm looking through the synonyms, being like, I've used this word 5 times. How do I use another one? And all of the words then sound amazing. And then you put them in and you're like, why have I gone back to the 17th century and using this word, and then you take it out. So prefer the familiar word, even if you have to use it repeatedly to the far-fetched is usually better. Prefer the concrete word to the abstract. Prefer the single word to the circumambulation. And prefer the short word to the long. Long words sound really good. We like to use them, but we do not want to use long words for the hell of it. Short words are usually to the point and better. The people who write the best and who are experts in their field and, you know, who are really know their material inside out can tell you it in very, very simple and very short terms. Prefer the Saxon word to the Romance. What do I mean by this? Can we have someone, has anyone raised their hand or? Okay, by Saxon words to the Romance, I mean use plain English, no Latin. And I know it's really, really hard as lawyers to not use Latin. And it sounds very nice to be like, oh, this is so mutatis mutandis to this, that, or the other. It's usually just better to use English wherever possible. In the very rare circumstances where you have to use Latin and there's no English word for it, we can use Latin, but much prefer the English word. Use simple words and phrases. For example, use try instead of endeavor, help instead of facilitate, show instead of demonstrate, use instead of utilize, ask instead of inquire. Every time we want us to use the simplest term with which you can understand the concept. Has someone raised their hand? Go ahead.
Hello, I would like to ask a question with reference to these Latin terms. I wanted to ask that obviously as a student of law, I've seen that whenever we use these Latin terms, we are always word marks and our vocabulary matters a lot. So does using simple words actually deteriorate our point, or what does it mean for that? Because we obviously do not get higher marks when we use simple language.
I think that you actually would get higher marks if a simple language was just used. I know it's really, really nice to use the Latin, and I will be going through the Latin in a bit more detail later on in terms of, you know, instead of inter alia, even just say among others. There's no need to use inter alia for no reason. You have an English equivalent, which is easy to use. And where we have that, we should use that. Yeah. And I know that law schools here do it a little bit different. In the UK, they really don't like you to use Latin for no reason. But here it might be something that, you know, it adds some flourish or something to your writing. But I think it's usually better to not use Latin where you don't need to use it. Yeah, does that answer your question? We will go through Latin phrases a bit later on and be like, oh, how do we not use these? Okay, I will assume. Can we have him unmuted? I think he's raised his hand again.
Yeah, I'm sorry for raising my hand again. I just had another question. When we use these Latin terms, these are always explained to us in Latin. Whenever we are reading the book in the UK and everything else. So why aren't we, you know, taught among other things or something like that? And the fact that we have to use, you know, this high vocabulary so that we can actually gain the attention of the reader in the first place. Obviously, in the introduction, we are always advised to use that type of language. Is simple words going to suffice in that?
I think it should suffice. I think that everywhere else we are moving away from using Latin. Latin is a dead language. You really don't need to use it in your work when you don't need to. If the people at your school are all about you using Latin, fine, but take it with a pinch of salt, because I really don't think that explains your work or improves it to a level that justifies its use at all. And we will go through the terms that you can use instead. There are some terms that it is very hard to explain in the English as well. So when the English doesn't add anything, and I think res judicata is one of them. I think amicus curiae is one of them, because even then when you're explaining, you're like friend of the court, you know, it doesn't really add much to not call it amici to the court. But there are other phrases like inter alia, like the ones that we're going to look at, they can be easily, you know, substituted for the English. Okay, exactness in the use of words is the basis of all serious thinking. Words are clumsy tools, and it is very easy to cut one's fingers with them. And they need the closest attention and handling. but they are the only tools we have, and imagination itself cannot work without them. Words are very important. Being precise in how we use words is literally our job. And so we have to be very, very careful with how we use words. So we want to avoid fuzziness. This is an example. One aspect of the conditions necessary to the actualization of the rule of law is the process of creating meaningful access to justice. What does that mean? It's very fuzzy. It sounds incredibly high, registered, convoluted. One aspect of the conditions necessary to the actualization of the rule of law is the process of creating meaningful access to justice. Do you mean the rule of law means little if people cannot have their day in court? It's a much nicer way of saying it. It's much simpler. You can understand it. The minute you read that, it's much shorter, concise, not fuzzy at all. We know exactly what this person is saying when they say the rule of law means little if people cannot have their day in court. Yeah? So that's what we're talking about. That's the kind of difference we want to bring in your writing, in terms of when I'm given a lot of legal writing in the form of an article or a research paper, and that's what I'm editing for, right? It's editing to make it simpler, to be like, is this what you mean? Is this what you mean by this? I don't understand entirely what you mean by this sentence. It's about cutting out all of that and getting to the bare bones of the matter, right? And every sentence should have one simple idea. And that idea should be simple and it should be explainable. The rule of law means little if people cannot have their day in court, right? We don't need to give that a lot of, one aspect of the conditions necessary to the actualization of the rule of law is the process of creating meaningful access to justice. It's not necessary. Say it simply, say it so everyone can understand. Unfortunately, lawyers by nature are very wordy. Everyone that you know who became a lawyer, the ones that, love to debate and talk about, have their own little moot court in their families, that kind of thing, they are often the talkers in the family. So they love to use words. They love to say on the grounds that, or for the reason that, when they could say because. They say in the event that, or under circumstances in which, when they want to say if. They say with regard to or concerning the matter of, when they could just say about. They say has the opportunity to or is able to when they mean can. Look for these fuzzy phrases in your writing and eliminate them. The thing is, once you read something like this and you look through your own writing, you realize that you add a lot of flourish and a lot of extra words when you don't need to at all. If you've ever written a long piece and then you've been told to edit it down a number of pages, you'll be like, no, impossible. Every word here is precious, is gold dust. I need everything here, without which I can't say any of what I want to say. And then you cut it down and you're just like, okay, this is way better. This is totally fine, actually. And you know what? It reads quicker and it reads simpler. So it's like point. You've taken out all of the in order to's. You've taken out all of the is able to in the event that. And it just reads like a better piece of text, right? Because people who are reading your text, be they other lawyers at your law firm, be they, the readers of your articles or blogs, be they the judge, they want to be able, they don't have enough time to sit there and be like, okay, what is this person talking about? And we're going to go through signposting and structure and how you can help with the structure. But they want you to hammer the point home. And I like it when people hammer the point home very simply and tell me exactly what they want to say. The amount of pieces of writing I have where I take an entire paragraph and I'm like, this is the line that just says what this entire paragraph you've written about. It means that you need to cut out fuzziness in your writing. And I'm guilty of that too. In the end, when you notice it in your own writing, you become much more discerning and you become much more like, okay, that all needs to go. I basically said in a paragraph what I could say in a sentence. Passive versus active voice. Lawyers overuse the passive voice, sometimes because they know no better, sometimes to avoid assigning responsibility. Which one is the active one and which one is the passive? Will Smith hit Chris Rock at the Oscars, or Chris Rock was hit by Will Smith at the Oscars? I think we have a hand raised. Go on.
Assalamu alaikum. I think the first one is active voice and second one is passive voice.
Yeah, exactly, right? So Will Smith hit Chris Rock at the Oscars, that's the active. Chris Rock was hit by Will Smith at the Oscars, that is the passive voice. You want to avoid using the passive voice, right? Keep on using the active. And we'll talk about the instances where you can use the passive voice, but generally try and use the active. The active is the court reversed the judgment. The passive is the judgment was reversed by the court. We want to use the first one, right? It's more active, it's more this happened, not this was happening by this, okay? Passive out, make sure everything is active. The court held, the court ruled, the court reversed. Passive is the ruling was made by the judge. This happens a lot in Pakistan. A lot of people like to use the passive tense rather than the active. I think it's because everyone does that at every stage. Like judges do it in their judgments. Lawyers like to write in the passive. It sounds a little bit more detached. It sounds a little bit less, it almost sounds a little bit more intellectualized because you're so detached from the action and what's going on. But it is always better to use the active. The ruling was made by the judge. The complaint was filed by the plaintiff. It was held that. Active is the judge ruled, the plaintiff filed a complaint, the court held. Also because you want to say that the court held, you want to say that there is someone who did perform this action, who did this, right? And you want that included in the text. But we do use the passive in certain circumstances. So to emphasize the action rather than the doer, trespassers will be prosecuted. We don't know who the trespassers are or who they'll be prosecuted by. We don't want to talk to you about that yet. We want to emphasize the action, which is do not trespass. Trespassers will be prosecuted. You can use the passive tense there. To draw attention away from the performer of the action, sometimes when you guys are writing legal briefs or writ petitions, you want to leave it very, very vague who did something. So you want to say something happened, but you don't want to attribute it. Maybe you don't want to attribute it to your client. Leave that vague. You can use the passive then. When you really want to emphasize the facts rather than the person who did them, such as a result of the accident, the windshield was smashed, the front passenger door pulled off its hinges, and the front wheels misaligned, or when the doer is not known. So both of those times when you don't want people to know who did it, when you want to emphasize the facts, not the doer, and when the doer is not known, you want to then use the passive to hide the identity of the actor. Mistakes were made. They weren't made by my client. They weren't made by anyone else. They were just made generally, right? That's the kind of stuff that you want to use the passive for. And also to vary the sentence structure. If you're going to have for every sentence, the court held this, and then the court held this, you also want to put, it was held by the court that. Just to vary it, mix it up a little, you can use the passive then, okay? Otherwise, active voice, always. The court held, the judge ruled, the plaintiff filed, that kind of thing. Nominalizations, we love to use these as well. I don't know, this is always when you're then going and cutting out words, especially if you have a word limit, then you realize that there is so much of this that you're doing and that you can take out the extra verb that you've added for no apparent reason. The court reached a conclusion, it granted a continuance, he was involved in a collision, he took action, right? These kind of things, don't turn the verb into a noun and then add an extra verb, just use the first verb. He concluded, it was continued, he collided, he acted, that kind of thing. Just use the first verb. It will make your writing simpler, it will make it shorter, and it will make it clearer and less fuzzy and convoluted. Don't use run-on sentences containing numerous qualifying phrases. This is also an issue. For instance, the court in Chester versus Morris, a case involving a similar traffic accident, held that a person riding a bicycle must adhere to the same standards as a person driving a car, although it limited its holding to the facts of that case, which included the fact that the bicyclist was intoxicated. What's the issue with this sentence? It's a very long sentence. I think Lewis Carroll had the longest one in Alice in Wonderland, which was like 100 words in a sentence, which is like a paragraph. This kind of reminds me of that. What's the issue with this? Anyone? Even reading it, you have to take a break because it's so long, the sentence, right? Javeria.
Can you hear me? So there are no connecting words and the sentences don't stop. We only see commas.
The sentence what, sorry?
Sentences are continuous and there are only commas and there are no connecting words.
Yeah, exactly. It's too long. It's using run-on sentences. You're qualifying everything within the sentence. It's really difficult to read. You have to keep on you have to reread it to understand totally what the facts are, right? You need to use several short sentences. Chester v. Morris involved a similar traffic accident. The court held that a bicyclist must adhere to the same standards as the person driving a car. The opinion is limited to situations in which the bicyclist is intoxicated. It's much clearer, much simpler, much more easy to understand, right? And this is the benefit of using several short sentences. If you are saying different things, every idea has to be in one sentence, okay? Chester v. Morris involved a similar traffic accident. The court held this. The opinion is limited to this. You don't want to make all of these three different points in the same sentence. So split them up, short, punchy sentences which say different things, and don't use fuzzy language. So this is also an issue with writing, also because law firms generally really do not like you to use this in writ petitions, but also it kind of translates into other opinion pieces. People really don't like using the first person. They don't like to say, I think this. Lawyers will turn somersaults to avoid using the first person. They will say, in my opinion, it is not an unjustifiable assumption, which should just be, I think this, right? And that was something that I kind of had to also train myself out of, which was, and even now I find it really difficult to say, I think this, I believe that blah, blah, blah. But it is really something that I was taught on my LLM to do, which was that just say, I think this about the state of the law today. I side with this, judge on this position, blah, blah, blah. And I explain why. You have to have opinions. They really like it if you do have opinions and you show your working in terms of, this is what the issue is, and I think this, I believe this. We kind of look for that in you because instead of hiding your opinions behind the general argument of the piece, just say what you think it is, right? Don't shy away from saying I. And I know that for those of you working in law firms, that is something that you will find really difficult to do because it is frowned upon. And in writ petitions, it really doesn't have any place. In appeals, it's not about you. Americans often like to use the words we think, we believe in terms of when they're referring to themselves and their client. It kind of hasn't transpired here yet in terms of the written, even if people will say that in court. But generally, yes, don't shy away, especially if you guys are writing. Lawyers often write a lot. They write blogs, they write opinion pieces, or they aspire to writing. So when you do that, try and talk and have an opinion and don't shy away from what your opinion is. Do we have a hand raised? Go on.
Yes, ma'am. I want to ask a question that which books should we study for legal writing in Pakistan? Any book suggestion?
Any books? So there are the Elements of Legal Style. That is, I think it's by Brian Gardner. I was reading this in preparation for this class, and it's very good. I do not go through grammar, punctuation, that kind of thing, but it goes through.
You type the book name in the chatting box.
Sure. We can add that to the chat box. There is also Writing as a Lawyer by somebody Goldstein, and that is also a really good book to read, and it kind of teaches you as well. It gives you like long examples of what good writing and what bad writing is. So that's a really good book to read as well, and especially if you want to get to the nitty-gritty of how do you use punctuation, how do you use grammar, what kind of word use is acceptable, what isn't. Those are really good books to read. Okay, too many young lawyers today are afraid to show strong feelings. No problem. Too many young lawyers today are afraid to show strong feelings of any kind. And I think, we say that about young lawyers, but it's actually been taught to us by senior lawyers, so they're to blame. The jargon in which they write illustrates all too graphically their insecurity about stating what they believe in. They rarely use a straight declarative sentence or the pronoun I. Even when I'm checking articles or blogs or papers, I'm always like, but what do you think? You kind of ride the fence to the end a lot here, because you're kind of giving, this is the position here, this is the contention, this is where the two parties lie. But then I'm like, what do you think? That's the whole point of your writing, right? It has to be like, I think this, I believe this, and this is why. So yes, don't shy away from using I. Toss out timid phrases. Lawyers are known for qualifying every statement they make with weasel words. So you're saying stuff like, it seems, it would appear that, it might be said that, at least as far as X is concerned, it is respectfully suggested that. They come across as timid and doubtful. It's better to state matters confidently and straightforwardly, right? So you're trying to say this is the state of the law today, and it's better to do that confidently and straightforwardly rather than, and every book that I've read on legal writing is all about tossing out those weasel words. I find it very funny that they call it that from the beginning, but yes, it seems, it would appear that, it might be said that, at least as far as X is concerned, it is respectfully suggested that. Toss those out, make sure that they're not in your writing, make sure that your writing is less timid, more confident, and try and see whether it makes every sentence more punchy. I think it definitely does. At the same time, be very careful about this. Don't put in empty dogmatisms. So you often have lawyers overqualifying, they say like to everything, their answer is always, it depends, it depends, it depends. But you also can't use dogmatic words and phrases. Words such as obviously, clearly, and undoubtedly are always suspect. It means that you're engaging in hyperbole. Don't use obviously, don't use clearly, don't use undoubtedly. If you use incontestably to preface a conclusion about a contested issue, you weaken your argument. And I get that a lot in terms of students writing and explaining a very, very complicated legal issue in which you have a number of students, a number of courts who have kind of like gone back and forth on the issue. And they're like, so obviously the law is this. And I'm like, we don't know what the law is. That's why it's at this level. That's why we're having you write a paper about it, right? It's really not clear. It's not obvious. It's not undoubted, and nothing is. And so you want to kind of hedge your bets in that way and say, these are the issues in the law. And you want to say those clearly, you want to say those confidently, but you don't want to use empty dogma. Okay, you don't want to say that anything is clear. Very rarely in the law is anything incredibly clear. And especially when something has gone up to the Supreme Court, and that's the reason why we're talking about it, it most likely is not going to be clear. So try and do all of these things at the same time, which is not be too timid or doubtful, be confident, use I, give your opinions, and also discard empty dogmatisms. We do want to qualify where there is a need to qualify. So you do want to say that sometimes this can happen, sometimes this is the case. It may be that this is the case, but at the same time, state that confidently and don't engage in dogma. The amount of times I've had to cross out, I'm like, really, is that clear? Because to me, this law is not clear at all. It's very confusing. Yes, so we don't want to be engaging in that. Going back to the Latin point, good writing is plain English, okay? The amount of Latin that we use, the amount of legalese, pomposities, bureaucracies, we want to cut down on that majorly. Lawyerisms are words like aforementioned, wherefore, res geste, and hereinafter. They give writing a legal smell, but they carry little or no legal substance. When they're used in writing addressed to non-lawyers, they baffle and annoy, okay? We want to avoid using terms like this because they really don't add much to the writing. I know I am so guilty of using aforementioned because I thought that it was like the coolest word ever, and I thought that it made me sound like an intellectual, like, I was out of the 1700s and here I was, talking at the roster and giving like a great point. You don't need to do that, okay? You want to write simply, you want to write so everyone can understand. Aforementioned, wherefore, hereinafter, we really don't need this. It's like that meme about using the word thus and how you feel when you use the word thus. It's all about how you feel, but I don't think they add much substance to the writing. And when the style doesn't add anything to the substance, in the sense that it actually takes away from where it kind of annoys, baffles other people, you want to do away with it. You don't want to have that, yeah? There are a few comments coming in the chat. I don't know what to do about those. So why do we like to use legalese so much? Some speculate that lawyers' language serves as a secret handshake in a fraternity, letting others know you are one of the tribe. So the fact that we can write and talk about the constitutional terms, and we can talk in gobbledygook, or people call it legal gook, means that we're, a caste apart, we're a set apart, we're lawyers, we know these Latin terms, we could throw them about willy-nilly, and we understand each other, but you guys who are non-lawyers, you guys don't get it. We need to do away with that. We want to have a law which is open to the public and which the public can understand very, very simply, and they're not going to be able to understand a dead language, which is Latin. So let's let go of the legalese and of that amount of Latin. What lawyer, this is a quote that I brought out, which really, I was like, yes, this is exactly why we need to do away with that, because it does set us apart from everyone else. What lawyer was not struck to learn in the first year of law school that an action sounds in tort? I hated tort. And actually that's the only thing that made me realize studying tort was the thing that made me realize I am not a lawyer. I hate this subject. And yes, but knowing things like that, we were stepping away from our friends and college classmates, leaving them behind. They were becoming non-lawyers. As in the UK, especially when you become a lawyer, you're doing it at 18. Similarly here, the minute you turn 18 and you start your law degree, you are referred to as a lawyer, and everyone else is a civilian, they're a non-lawyer, they don't know the stuff that you know. There was something much less. They were the laity. They're the people who don't understand the law, who are ignorant of the law. They're not like you. Alone among professionals, lawyers exclude the rest of the world in their very name for others. Who has ever heard of a non-teacher, a non-journalist, or a non-doctor? And yet we are referred to everybody else as non-lawyers, especially those who study IR and then come and work at international legal think tanks. We all refer to them as non-lawyers. We don't need to. Lawyers are not a class apart. We don't need to use legal jargon. Okay. So every time you're attempted to use herein, herein above, herein under, or similarly therein and its corresponding variants, try here or there or above or below and see if it doesn't make just as much sense. That's another one I'm guilty of. Therein, herein, we don't need to use these terms. Try here or there or above or below. It will make your writing much more readable and much better. And what you want to attain is readability. If you can give it to a non-lawyer and have them understand exactly what you're saying, that is an achievement. Oh, these are all like messed up, but at the present time, we should just say now, these are the kind of pomposities and bureaucracies that we don't need to be using in our writing. At the time when, by means of, just say by, for the duration of, just say during, for the reason that, just say because, in case, say if, in order to, just say to, in the event that, just say if. Is able to, say can, is entitled to, may do, it is directed that, must, notwithstanding the fact that, although. Notwithstanding the fact that is something that comes up again and again, I'm guilty of it also, just say although. These are much shorter, much clearer, much simpler words that you can use instead of all of these. And these are the kind of things that you see in legal writing so often. And it's about getting to the point where we do away with these bad habits and we write simpler. Is when you read, so in international law, there's James Crawford, who is, the father of not the father, but like the current main legal mind of international law. And when I read his writing, the only thing that strikes me is that it's so incredibly simple. It's incredibly simply written. He's describing very complex themes and theories, and he's doing that in a very, very simple way. And that's why you get so taken in by all of his theories and his view of the law, because he describes it like that. If I'm reading a text which is very, very convoluted, I can't really tell you what that person is thinking, what their opinion is, and then I'm always going to side with Crawford because I feel like that style is just so much more approachable. And it's something that you can then parrot on so easily because it's explained to you so easy. So now if someone tells you what happens when you go into a black hole, I can be like, you turn into spaghetti, right? Because it's so easy to remember. If it was all of this stuff about particles and, anything else physics related, which I don't know anything about, it would be much, much harder. Yes, I think we have a question.
I don't know if this was working. Can you hear me?
Yeah.
Okay, so my question was that all of the things that I've noted down, it feels like the legal writing is getting more and more informal as we go along, since the lack of all these legalese and stuff, it just feels a lot more informal now.
Yeah.
Is it how it's supposed to be?
So I think that that's how it should be, actually. And I think that I remember seeing my first writ petition when I worked in litigation, and it said respectfully sheweth. And I was like, what the, like, what century are we in? It sounded like something very Shakespearean. It sounded like, you know, Chaucer's English type thing. And I was like, who uses these terms? Nobody uses these terms outside of the law. And now people have evolved since then. There are so many more law firms which now just say respectfully, and then they carry on. And I think getting these terms and making it more approachable to everyone, because you don't need a register of English wherein you can understand wherein, heretofore, like aforementioned. You don't want to have these words which kind of essentially gatekeep in terms of, oh, you need to know this like very old brand of English to be a lawyer. We don't want to have that. We kind of want to move away from that. And actually the best writers of today, the best people who are thinking and, you know, talking about the law are the ones who are doing it very simply. And they're the ones who could probably explain to a 5-year-old what the law is, what it's there for. There was one document that was going around on Twitter, and it was about someone in family court in the UK, and the judge had written a letter to the child to explain exactly what was happening in the custody proceedings. And it was written so simply that a child could understand. And it was so nice to read, because I really felt like the law, especially as it deals with minors, it deals with non-lawyers, I'm using that term again, it has to be something that is accessible. Otherwise, where is access to justice? And the first thing that we need to do is make legal writing such that you do away with all of this pomposity, all of these legalese that actually end up gatekeeping, right? Because as lawyers, I often feel like they want to be the only ones to know the law. Often when they're like really complex legal concepts, they'll be like, oh, look, a non-lawyer is commenting on this. Does that person even have a law degree that they're commenting on this? And I'm like, the law is something that touches everybody. And it is something that everyone has the right to expound upon, to talk about, and to discuss. And the more we gatekeep and say like, no, you have to be qualified, you have to have an LLB, you have to be, you know, licensed to be able to talk about all of this, the more we do it at our own expense. Because I feel like in the future, if this carries on, the public are going to be like, to hell with lawyers, we hate them all anyway. Let's have a justice system that works for us, because I don't think currently it does. When you have laws which are so obscure, so complex that they're hard to explain, when lawyers don't even understand what the other one is talking about a lot of the time. I read a lot of legal debate, and I'm always just like, can someone explain this to me? Like, I'm very, very dumb because I don't understand what is being talked about. And the more we move away from that, the more we try to move away from that, I think the better. That was a very long answer to a very simple question, but I hope I answered it. Yeah? Yes. Okay. An example. So you can either say 60 days prior to expiration of the license, or say very simply 60 days before the license expires, XYZ, right? Enclosed herewith, please find, and then I am enclosing. Very simple. Anyone can understand these. The ones prior, you can't understand as well. It's about simplifying, right? And it makes the same point, fewer words, simpler. Legalese, so the question asked about that. This is the kind of thing that we need to do away with. Ab initio, we don't need to use ab initio and have everyone look it up. I remember the first time I heard mutatis mutandis, I was like, what does that mean? And I had to go and look it up, and I still don't really understand where or when it's used. But international lawyers especially love to use that, and they love to use French. Ab initio, from the beginning. Arguendo, you can say for the sake of argument. Inter alia, among others. Sui generis, one of a kind or unique. Vel non, or not, or the lack of, right? We don't need to use these legal terms. these Latin terms, they really don't add much to the writing apart from make you feel very superior. So let's get rid of these. Ab initio from the beginning, arguendo for the sake of argument, among others, one of a kind is unique. That kind of thing we should be moving more towards. Okay. Let's keep going. Okay, now we're getting to the point where we're writing and you want to come out with an outline. Just as you wouldn't go on a cross-continental trip without a map, you shouldn't start writing sentences and paragraphs before you have a plan for the entire piece. If you begin with a fairly detailed outline, you're better able to know the relevance of what you write in any given section. And you reach your conclusion only after working through all the necessary steps. This is something I'm very guilty of. I hate doing outlines, but I know that they are so important. Once you have an outline, it's almost like you just flesh it out and the piece kind of writes itself. Often when I start and I don't know what I'm arguing, it is really, really hard to get a good piece of writing out of that. There are so many pieces of my writing that people then look at and they're like, what is the question that you are answering? And I'm like, the question is really obvious. It's like, you know, if the sky is blue, why is this happening and that happening? And they're like, that's not clear. And so often when I ask people who are writing for me, I ask them to sit and think, what question are you answering with this piece of writing? And if they, you know, if they're flustered, which is what I always used to get, if they're kind of like, oh, and they're kind of reaching, I'm like, go and sit down, think about what question you're trying to answer, and then write the outline, and then it will, you know, it will flesh itself out. There are a lot of pieces of writing where they don't know what question they're answering, and they're just hoping that they're going to find it on the way. And as much as I have tried to do that, it never, ever, ever works. So try and have an outline, try and know the map. And a lot of people like mind mapping. I find it a bit too arty for me, and I kind of just like mess it all up. But mind mapping is really, really good. You have the central question, and then you have what you're trying to write about in every kind of cloud that goes off it. And if you have subpoints, then they go off the cloud, and then you kind of cut it down. So mind mapping helps. Having an outline really, really helps. The best thing that I ever learned about structure is incredibly, incredibly simple. And I do this all the time. In every piece of my writing, ever since I heard this, I make sure to do this. In the intro, you have to tell people what you're about to tell them. Then in the main body, you tell them. And then in the conclusion, you tell them what you've just told them, right? You want to have a very, very solid introduction, which is, this is what's going on, this is what I'm going to tell you about today. Then you have to tell them. It can be as long as you want it to be. And then in the conclusion, what you have to make sure to do is not bring up any new points. So it can't be, this is what I've just talked to you about. And do you know what? I just had this thought that like, oh, this would also apply to criminal law. That has to be a new paragraph in the main. Your conclusion is just, this is what I've just told you. And that's it. It can be flourishy. You can bring in like, you know, new quotes or that kind of thing. I usually like to end with that kind of stuff, but it should just be what you've just told them. Don't bring in any new points. Don't be like, actually, do you know what? There's this entire other thing, which would be quite interesting, right? But I didn't talk to you about it, but I've just thought about it now. No, if you want to put that in, you have to add a new section or take it out. Just tell them what you've just told them. Apparently there's a quote by Winston Churchill, I think, about this, where he's like, when you want to say something, just hammer the point home. And this is what I think about when I do that, which is that you're hammering the point home. You're telling them what you're about to tell them. You tell them, and then you tell them what you just told them. Okay. In terms of structure, these are the kind of questions that you want to be asking yourself at the end. Is your intro effective in providing a roadmap, right? That is what your intro is there for. It's kind of to frame the issues and to be like, this is where we're going to go today. And you have to tell me if you have to answer if that's effective. Does your conclusion, by the time you get to your conclusion, have you traveled the map and you've got to your destination and you're like, hey guys, look back, this is where we've traveled to. Does every paragraph make only a single point? This is kind of a bit murky. Sometimes you can have different points in one paragraph, but generally the theme, every new paragraph should have a different theme. It should be kind of relating to a different point, right? Is every concept discussed in a single place in the draft, or is the discussion scattered? Often you end up, because especially when you have like a little bit of a mind map or like a roadmap in your place, you're kind of like, oh, but I want to go back there and make a different point about that, which relates to this. If you're going to do so, it has to be signposted, but also try not to do that. It confuses people, and it's better to just have all of the discussion about one concept in a single place, and then do the transitions work effectively to connect your points. I want to be going in the map. I want to be going on a journey, right? I don't want to be going back on myself. I don't want to be skipping 2 points and going somewhere where I'm like, why am I here now? I don't understand. Link them together and kind of talk until you get to that conclusion, and then be like, this is what I wanted to say. I struggle with structure, and it's one of the things that it is the best thing to get someone to proofread your work and tell you whether the structure makes sense to everyone or whether it just makes sense to you. Often I like to make my structure very weird, and that is the main criticism I get back whenever I have my work proofread, and I try and have my work proofread and edited by like as many people, and we'll talk about editing. That is the main criticism I get back, which is, I don't understand how you have thought about this and why you structured it like this and why this is coming here and that's there, and wouldn't it be better to do this? And I'll be like, but it makes so much sense to me, but it doesn't make sense to other people. When it doesn't make sense to other people, change the structure. Length does not equal effort. It's that whole thing about someone saying like, I'm writing too long because I don't have time to write you a short letter. And it's because it does take more time to write a crisp, tight, concise piece than a loose, long, baggy one. And I think especially here, we kind of equate length with a lot of effort. Actually, you want to have a very, very short piece, which is effective and crisp, tight, concise. You don't want to have a long, rambly, baggy one, which is making the same points in 30 pages that could be made in 10 pages. So let's make sure that the length is something that is concise. It does not equate to effort if you produce something of 50 pages when it could be written in 10. It requires more discipline to sift through and evaluate one's research, select the best items and discard the rest than to include every case and every citation. There are often so many pieces that you're like, I read this really interesting article or case and I'm going to mention it even though it's totally irrelevant and I don't really need to be mentioning it, but I read it and I really like to, I want to prove that actually I read like a bunch of sources, so I'm going to include that here. When you're going through the editing process, it's much better to go through and be like, do I actually need this here? Is this adding anything to the point that I'm trying to make? Is it going to help them get to the destination, or am I just stopping here for no apparent reason? If you give me, so this is a good quote, because if you give me an 8-page article and I tell you to cut it to 4 pages, you'll howl and say it can't be done. Then you'll go home and do it and it will be much better. After that comes the hard part, cutting it to 3. This is when you have the most wailing, especially if you're doing dissertation work, because you will have written, the idea of having written 10,000 words would have been so horrible and awful to you. And then by the end, you're like, I'm at 15,000 words and I can't possibly cut all of this. It's just such beautiful prose. And then you cut it and then you're just like, okay, this is probably much better. And actually, I don't even remember what I cut because all of it was superfluous. And then you cut it down to 3. I remember at the beginning, I used to have like a 3-page, as like, you know, a 21-year-old, you have like a 3-4-page CV. And I was like, and people told me you only have to have a 2-page CV, it should be much shorter. And I remember being like, but I've done so much stuff, I need to have like 3 pages to explain it. And then somebody really cut me down to size, being like, Obama has a 1-page CV, so I think you'll be fine. And I was like, yes, maybe I shouldn't include, you know, winning the SAC race when I was 5. You need to write much, you can write much shorter. You can actually cut so much out of your work. And anyone who does poetry, apparently that's so good for helping you edit. So if anyone has the option to do a poetry class, because they teach you then to trim, cut. And editing is really good skill to have, because once you edit all of your work down, and you go through all of the emotional labor and the trauma and all of that stuff, the next time you write, actually you do away with a lot of the superfluousness that you didn't actually need, and you write better. And that's one of the good things about being an editor, is that you read so many people's work that it actually makes your writing much better, because you have learned what works and what doesn't, and how to simplify, how to cut things out. Okay, editing. Readers have too much to read and too little time in which to read. Writers are always competing for the reader's time. If your syntax is tangled, your grammar incorrect, your vocabulary mistaken, and your phrases are thicket, your readers will stumble and lose their way. This is why you have to edit, and you have to try and edit. The best time to edit is to compose it really early and then to edit right at the end. And everyone will laugh and be like, yeah, sure, that's the plan, that's how it starts. But then you never end up composing early and you never end up editing. But editing is really important. And the more detached you are from your text, the easier it is to be like, this needs to go, this is not explained enough. And you need to ask yourself these questions constantly. What is this sentence doing? What is that one doing? Is that here for a reason? Why have I phrased this like this? Would I have to read this twice if I wasn't acquainted with the subject? And that is also why it is so important to have other people read your work. And the more people that will read your work, the better. And it improves your writing so much. I remember for my LLM dissertation, I gave it to a bunch of people to read, and I was like, please read this and give me feedback. And I think everyone told me the introduction was too long. And I was like, no, I'm so wedded to this introduction because I spent so long. I'd put in like God knows how many citations. But I was like, no, I think I'm going to keep it as it is, because I really like the way I've gone through history of where armed conflict started in the 17th century to today. And in the end, the comment that came back was like, why on earth did you have such a long introduction? I did not need to learn about the history of warfare. And I was like, damn it, 3 people, if only 4 people had told me, maybe I would have changed it. When people come back and they say, I can't understand it, this is an issue, that is an issue. They're not your enemy, they're your ally, and act upon it, and especially if 3 people are telling you the same thing, you guys, that would help. You should edit until you are satisfied or until you run out of time. You should press on friends and colleagues as many of your documents as their time and patience will permit. I try and send them to literally anyone who will listen. And yeah, people often don't have time and they don't have the patience, which is why you should have many friends and many colleagues, and then you can impress your work on them as well. And also be the kind of person who will offer to proofread everyone's work, because I think that's just a really good way of encouraging camaraderie and cooperation, collaboration in your workplace. I know that law firms are very competitive, so people don't often let other people read their stuff, but it's not a good practice. The good practice is to have people be critical constructively, not otherwise, and to take their comments on board, and also to do the same for other people. An outsider who tells you that something is unclear is therefore a valuable ally. There's little point in arguing with someone who says, I don't understand this. You may fully understand it. You may think that they're very stupid. And you may think that, like, oh God, how could you not? Is there in black and white? Your understanding is not the goal. If one person misunderstands, others may as well rewrite it some more, simplify it, try and figure out what they're lacking in their understanding, what you could write clear, and do that. So yeah, as many people as can proofread your work is the best thing. This is a quote that I really hold dear, and I kind of say it to everybody. There is no such thing as good writing. There is only good rewriting. Your first draft should suck compared to your second draft. Your first draft of your dissertation, of blog post, of an article, anything, it should be something that is you've written down, but that once it goes through the editing process is so much better than the first draft, that when you look at it, you're like, okay, I can understand that it's gone through a process, and now this is more refined, it's much better, and it's much easier, simpler, understandable, all of that kind of thing. There is no such thing as good writing. There is only good rewriting. So try and rewrite everything that you write. It will make your writing so much better, and be very critical of yourself, and it will help you so much. Now, the thing is that if you can write well, how do you get to the point that you can write memorably? And it's very different to be a good writer and to be, to be like, okay, I'm competent. I'm competent as a writer in that I can do all of these things, I can get them down. How do I make sure that I am a good writer? Every lawyer should strive for one original, memorable sentence in every brief. One sentence that the judge will borrow, one sentence that will be quoted by journalists. This kind of writing is difficult, for the most memorable sentences always sound as though they were composed effortlessly. The words are plain, homespun, evocative. The only answer I have to how you become a memorable writer is to read a lot, and to read a lot. The best writers, I think, are those that read, those that research, and those that are well read and come to it from, have read in numerous disciplines and then can come to the law. Especially what I usually tell people is that your research should be 7 times what you've written, right? So I just wrote a piece which is 11 pages long, and my notes for that were 40 pages. That is overkill, don't do that much. But generally, you should read so much more than you actually end up putting on the page. And that will show in the page, right? Because it will show that you have like this much knowledge and that you've put in this much. And whatever you squeeze out of all of that knowledge is the best stuff, and the stuff that you can then simply explain. So in order to get there to the point that you are writing memorably, it is important to be very well read. These are examples of very pithy, good phrases that that judges have said during the course of their judgments, and which we look to and we remember, and we're like, okay, this is incredibly memorable writing. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theatre and causing panic. That was Justice Oliver Wendell Holmes. It's often misattributed to him, and they take out the falsely to be like, you can't shout fire in a theatre and cause a panic. But actually what he said it was, you can't falsely shout fire in a theatre and cause a panic. Justice Thurgood Marshall, a sign that says men only looks very different on a bathroom door than a courthouse door, when he was talking about equal protection. This is stuff that can't be taught, it can't be learned, but writing memorably and developing your own legal voice, that's something that we're going to come to. That can only happen if you have a lot of reading, a lot of, just consumption of a lot of things, life experiences, films, even books, all of that kind of thing, that you can then distill in your writing, and that will help you, write persuasively and also to have your own legal voice. So writing persuasively. To persuade is to make the judge agree with you. There are 3 modes of persuasion: logic, where you're appealing to reason. That is often what we try and do. Emotion, or appeal to emotions. When you're reading family law cases, you see a lot of appealing to emotions. This also happens in human rights cases, constitutional ones. And credibility, or appeal to the character of the writer as reflected in the quality of his writing, right? So your pleading is an invitation to the reader to engage his mind, logic, heart, emotions, and attitude to your side. And I often find that the best forms of writing are the ones that do all 3. You can read a very logical piece, which appeals to reason, especially if you're doing like banking or tax or something which, you don't really require that much emotion for. But the best pieces of writing are the ones that cover all 3 and that appeal to you on all of these forms. So now we have an example of bad writing. I was kind of going to look for something which was really badly written. And then I remembered that someone had sent me this judgment, and it was, I kind of read this and I was like, oh my goodness, how could you? I mean, there was one recently where the judge had quoted Teen Vogue, I think. But this one, I don't know what the case is about. I think it is about a Toyota Corolla. It is about motor company and cars and etc. But he started it with this quote, and I don't know where the quote is from. We don't know. I think he might have made it up himself. For a man, new car owned is like a first girlfriend who introduced us to the feelings of butterflies in the tummy and goosebumps across the skin. It is a relationship that can keep you up all night. building castles in the air, but when she is away and not found, you miss her like the deserts miss the rain. I have no idea what this has to do with judgment. I have no idea why it is there. I don't feel very persuaded or very much like I'm reading good writing when I'm reading stuff like this. So let's try and not do this. This is from the prosecutor general when she was going up in front of the court to talk about a case where this person had committed war crimes in Timbuktu in Mali, and also crimes against cultural heritage. It's a very important case. And the way she presents her case in front of the ICC, I remember reading this and being like, this is beautiful prose. It kind of, for me, links all of the three, right? It's quite emotive. You can feel her voice coming out. It's quite emotive. It's very logical. And it's also got that a kind of a theatrical quality to it, right? Because she starts with, the case before you against Al-Hassan is extremely serious. Allow me at this stage to tell you what this case is not about. It's not a case against religion, nor against Islam, nor indeed against any system of thought or of law. It is quite simply a criminal case. And I really feel like the way she kind of says it is quite gripping. It's almost storytelling. So if you look at law and like writing legal briefs and writing writ petitions or even articles as a form of storytelling, and how you're going to, persuade in all of these ways the judge, is quite nice to read writing which kind of takes you through that and makes you feel like you're reading something which is kind of a story and you want to know more. The case before you concerns the man, Al-Hassan, who we allege is individually criminally responsible for Rome Statute crimes committed against the population of the city and region of Timbuktu. It is for this court to say and reach a decision that individuals such as Al-Hassan cannot, as members of armed groups, whatever they may be, occupy a city and a region and impose by way of prohibited violence on an entire population dictates on the basis of an ideological and religious vision or the precepts they claim to apply. Now, could that be a number of sentences? Sure. Could she have maybe broken some of the rules that we're talking about? Yes. At the same time, this for me is very nicely written. It's told as a story. It's told very persuasively. I want to know what he's done. I want to know what's happened in Timbuktu. I want to know what her argument is. And then I want to read the opposing counsels, And it's kind of the way she has put it to the court, I really like. It is for this court to say. She's kind of put it on them and reach a decision as to whether people like this can do what they've done or not, on the basis that they have claimed that they're doing this. And I think it's very powerful. I think it's strong. I think it's emotive. I think it elicits a lot of feelings. And when you read this, you're like, this is what legal writing is meant to be. This is why I became a lawyer. This is why I wanted to do international law, because this is the kind of stuff that you want to read about. And this is the kind of way you want it to be written. So yeah, look for examples of good writing and try and suss out what you like about the writing and why it really helps to read a lot of books, but also to read a lot of judgments like this, which are powerful, which are strong, and think about why they are that way. And now the hardest part is to then develop your own voice, right? Try to express yourself honestly, clearly, unpretentiously. Your natural voice will emerge. Once you kind of like shed all of like the hang-ups, the like, wanting to use Latin, wanting to use the passive voice, hiding your own opinions, that kind of thing, your natural voice will emerge. Law is not just a bunch of dusty old precepts to be applied with humdrum objectivity. It is alive, blood courses through its veins. Establish your tone, find your voice, and the only way you will find your voice is by writing a lot. Once you do that, once you establish your tone, you have to stick to it. Don't kind of like be the kind of person who just sounds like the last person that they've read. Find your voice, stick to it, and kind of use everyone and like imbibe them into your writing, everyone else that you've read, but stick to your own voice. Some law students emulate the style that they see in older cases when they first try to write legal briefs, apparently thinking that this is the way lawyers are supposed to write, but the result is writing that is artificial sounding and lifeless. Superficially, it sounds intelligent, but it is ponderous and dense, using a lot of words to say relatively little. And that's kind of what this legal writing workshop has been about, right? Write simply, write effectively, write concisely, write accurately. Don't use all of this stuff to make you sound intelligent. Don't write the way you've been taught to write by everyone so far, and the way law firms especially write. I don't think that that is good, and it's very lifeless writing. And I kind of think that as the new generation going forward, we kind of need to change all of that. At the same time, a law firm may impose certain style limitations on its lawyers in order to bring a level of consistency to the firm's work product. But still, you need not aspire to rigid conformity, even within the confines of legal writing. There is room for individuality, even if the law firm is very conformist. It really has a structure. It has a way that they want things to be written. Sometimes when they see writing which is really off-piece and very different, there is still room for it because they can acknowledge that it's good writing, it's a nice voice. It does what they want it to do, even if it's not the way that they have done things so far. The legal writer who is able to project an authentic voice while still maintaining a professional tone will produce a more engaging style of writing. So while it's difficult to define the concept of voice, it refers to a style that comes naturally to the writer, so that a glimmer of the writer's personality reveals itself through the text. And a writer's authentic voice lets the reader see that there is a real person behind the document, right? And you see that a lot when you look at the American Supreme Court, and when you look at the way the justices write, they have a very, very different voice. When you're looking at Ginsburg, when you're looking at Scalia, they have very different voices, and you can see the person behind the document, especially when you read Scalia. You're like, this is not a nice guy behind this. Same with Clarence Thomas, but they have a voice. That voice is authentic, it's genuine, and you can see the personality that is coming out through the text. So just, we're gonna end a bit early, and I will take questions and answers if any of you guys have them. But final thoughts are: read a lot. The best writers are those that read a lot. Write a lot, and have everybody read your writing, have everybody edit your writing, and take in everything that they say, all of the criticisms, try and take in all of it, have a thick skin, and edit your work, have other people edit it, and yeah, just keep reading, writing, editing. That's all of the things that you need to take away from today. Do any of you have any questions?
Hello, can you hear me?
Yeah, I can hear you. Yep, go on, I can hear you.
But usually people from legal fraternity usually recommend me that
No.
don't use I. It shows that some sort of
Maybe your mic is off. I can't hear anything.
Use the word that this could be argued. Don't use that. I think.
All right, can you say that again? I didn't hear you.
Hear me now.
Yeah, I can hear you now.
Okay, so is it all right? Okay, so that you said that you don't hesitate while using I think, right? But legal fraternity here in Karachi usually recommend me that don't use I think, because the what court demand is that what could be argued, write it as this could be argued, right? Do you got my point? Or still it's confusing?
I get it. I understand that, especially here, especially when you're writing writ petitions and law firms, they usually don't like you to use I. In other jurisdictions, they don't mind if you say, like, you know, we think, when you're talking on behalf of your client. But I think maybe that applies then more to, like, if you're writing a blog article, if you're writing other pieces of writing which are opinion pieces, which a lot of lawyers do, they don't shy away from using I. I understand if your law firm says don't use I, that's fine. So yeah, probably hedge with them on that sense. But otherwise, in your other forms of writing, don't shy away from using I. Okay, any other questions? Okay, I think that's it. Thank you so much for joining, and I hope you guys enjoyed this. Okay, Layla has a question.
Ma'am, Assalamu alaikum. I have a question from you.
Yeah, go on.
Ma'am, because I don't have internet facility, I joined very late this meeting. I could not understand what you have started, but I want to let you know from you that when this internship will be started and whether it would be online or in Islamabad.
It will be available online. It will be available on our YouTube channel, so you can check it out there. Everything that you've missed.
Okay, ma'am. Thank you.
Okay, I think Layla had a question.
Hello, can you hear me?
Hi. Yes, I can.
Okay, so thank you for your presentation. It was really clear and enlightening. First, I'm from Algeria, so I think I'm one of the few here who are from that part of the world. Just I wanted to ask you, because I am an Arabic native speaker. English is not my first, neither the second language. It's for us in this part of the world, we are more francophone than saxophone, so we speak more in Arabic or French. But then this really impacts the kind of writing and the style of our writing. So we are more influenced by the French style, at least here in North Africa. And here I want to ask you about something, because I am a researcher in international law. I do research in nuclear non-proliferation. It has a lot of political, like say, relation. And always when I'm trying to write an essay or a piece, even when I was writing my PhD, my supervisor was always like telling me, be aware, try to not get too political. You have to use only legal terms. You have to be so this is why I want to ask. But when I was reading English literature on the subject, I found that those English-speaking lawyers are more flexible. They are more free to use some more political thoughts and then give them the legal qualifications. Or so I don't know if it's only me or if someone like you can give me a clearer thought on that. That because I want to endeavor into writing in English, I'm not that. I don't have enough courage to do it, but assisting to your course maybe would give me a push to that. So I want to know if I ever try to write in English, would be the referees, the peers that would judge my writing more flexible than the Arab-speaking referees that I'm dealing with always. Thank you.
Yeah, that's a really interesting question. And I think that especially, I mean, the French system is so different, even even when you look at their civil law and their inquisitorial model is very different from the adversarial. And so I think maybe that also translates into how much politics you bring into the law. In the UK and I think in the US, because the law has to be about, current affairs in terms of like, it has to apply to how situations are on the ground. We like to use a lot of examples in terms of political examples. So you can't really get away from it when you do international law, especially because you have the law, you have the UN Charter, but how does it apply to actual things going on, actual armed conflicts as they occur, such as, Iraq or Russia, Ukraine. So I don't think that you can get away from the political. And I think it would be strange to write a legal piece which only focuses on the law and not as it applies to situations like that. And I know in the US and in the UK, they much prefer you to look at the law and to apply it there to those situations. So I think, and I think that you should definitely try out writing in English. Your English is great. So, and maybe you can put all of your politics then into your English writing.
Thank you.
No problem. Any other questions? Okay, I think that's it. I don't see any other hands up. Thank you guys so much for coming to our first legal writing workshop. I hope you guys liked it. If you have any feedback, please email it to us. We'd be more than happy to, act on it. And as I've said so much about editing and getting other people's feedback, so definitely then write to us. But yeah, I hope this has been good, and I hope that you've learned